Actually, Jimmy, that laptop's not working. Do you want me to get one from another courtroom? Is it okay? Is it okay if it's not?
No, his eyesight's failing.
Sorry?
His eyesight's getting worse.
Shall I get one? To I'll just go and put this in the other room.
Thank you.
I did in the other room. So I'm not going to record, so I'm just going to leave it there.
Can I? Oh no, it's not. Oh, we need to go.
I don't think you'll be sitting here. It's too tight in here.
Yeah, but
You know,
even if it isn't.
You know with the water, if you bring it, you've got to take the...
Yeah, but
the clear up.
it's got to be the next day.
Yeah, that's fine.
Yeah.
As long as it's done.
Yeah, that's fine.
So you are sitting in the judge's chair?
No.
No, you're not. Can you just do me a favour, when
Oh,
they're ready, knock, courtroom is ready.
Thank you.
And you'll get my email when it's all sorted.
I won't be here, but thank you.
Okay. You'll see my email then.
I'm not coming tomorrow.
All rise. Appeal part heard in the matter of National Union of Professional Carers and Officer and others.
Sorry to have kept you waiting, Lord Henry.
Not at all, my lord. My lords, I hope to be no more than half an hour this morning to allow Mr. Burton to complete our allocation of time. Lord, two quick housekeeping matters. One is that we printed, or we invited my Lord Justice Underhill's clerk to print sections 178 and 179 and give them page references to insert in relation to a rather peripheral point I made yesterday. The other is to answer the query my Lord Justice Underhill put to Miss Krasnow about the history of registration and certification. I can deal with it in two sentences. Voluntary registration of trade unions originates in the Trade Union Act of 1871. Registration then with a registrar of friendly societies.
Yep.
Certification of independence is a concept apparently introduced in the 1971 Industrial Relations Act, and it was a condition for registration under that act that a union should be certified as independent. So those concepts have now become what your lordships are aware of in 1992.
That's what I remembered. So that when, in modern times, the change was you had to be certified as independent, which had various criteria, but there had been a separate concept of a list.
For a very long time.
And the two are now brought together in a single act.
Yes.
Thank you. It's
And
very
the
helpful.
consequences of registration and listing have changed over time, of course,
Yes.
and the concept of certification as independent is, of course, a key factor in the Schedule A1. Lords, this morning I addressed the question of justification, in other words, Article 11.2. I only propose to supplement what my learned friend Miss Krasnow said yesterday. Lord, the question here is, of course, one of necessity in a democratic society, which your lordships are aware of from the Strasbourg authorities, is translated as a demonstration of a pressing social need. Lords, this question was addressed by the Employment Appeal Tribunal below at paragraph 114. Well, it's really at the foot of 112, having dealt with prescribed by law at H on page 115, or it may be 114 in your lordship's copy. At the end of paragraph 112, they address necessary in a democratic society, and at B they ask, does the measure seek to achieve a legitimate aim? 114, two aims. First aim, maintaining a distinction adopted by the legislation between workers under a contract and those not, and their second aim is protecting the rights and well-being of foster care. And that point is developed in paragraph 115 in the first sentence. First of these aims, perfectly legitimate one to pursue, a broad margin of appreciation, proper balance between the respective interests of labour and management, member states entitled to draw a distinction between different groups, and they cite authority for that. And if your lordships go to paragraphs 126 and 7, under a heading which appears above 123, is it proportionate? At 126, just by letter F, the tribunal says a measure permitting listing of any trade union, irrespective of whether its members were workers, would erode the distinction that Parliament has sought to draw between those with contracts and those without. And at 127, in the last but one sentence, just above letter C, they say Parliament has achieved a fair balance between competing interests of workers and management. So, my Lords, it's that first question which I addressed firstly and briefly. My Lords, of course we accept the distinction between workers with a contract and workers without may be legitimate and may be useful for a number of purposes, but that's not the question. The question here is whether the restriction in issue pursues a legitimate aim. In other words, whether the restriction on listing this union pursues a legitimate aim, or a union composed of this class of workers pursues a legitimate aim. That appears to us to be a question which the Employment Appeal Tribunal didn't ask, and it's not one which Parliament has apparently ever addressed. Of course, they've addressed the issue of distinctions between classes of workers with contracts and without. That's apparent from section 296. But it's not evident that they ever addressed whether that was a justification for not admitting to the list a union of workers without contracts. Laws in our submission.
Sorry to interrupt. Is that, just to make sure I've understood the argument, you're effectively saying that the tribunal have treated the differentiation per se as the justification?
Yes.
Said it's differentiated, ergo it's justified. Not quite correct to say that they haven't considered that, because they've treated this as really an incident of the margin of appreciation. You may have a lot to say about that.
Yes.
But that's the justification for it.
That's right.
But for that, it is, they just say differentiation equals justification.
Exactly so, my Lord. They haven't made that linkage of the justification applying to this particular restriction.
No, they haven't gone to explain why there is a justification for
Indeed.
that difference.
My Lord, Lords, we say that the distinction as a justification for this restriction is irrational. And the reason that we say that is that it's irrational to permit trade unions where non-contract workers are in a minority to have a union, but to exclude trade unions where non-contract workers are in a majority. And it's that distinction which, in our submission, is simply unjustifiable. And we say, Lords, that it's no answer for the certification officer and the Secretary of State to point out that in either a union with a majority of contract workers or a union with a majority of non-contract workers, in either of those, foster carers without contracts will be denied trade union and other rights which are dependent on contract. The question whether the restriction on those rights can be justified is a question for another day, whenever a foster carer seeks to rely on such a right which is dependent on the demonstration of a contract. The point in this case is that the trade union that they wish to form and join, to use the words of Article 11, is denied its rights to be a union. And Lords, we say that that is significant.
Is that a useful distinction? Trade unions exist only to further the interests of their members. I think I'm right, I think you told us last week that there is Strasbourg authority that unions are granted rights under Article 11 as well as their members.
Yes, indeed, my lord.
But even so, in this context, I'd have thought the rights of the member and the rights of the union come to the same thing. So I'm not quite sure why you're distinguishing between the two.
My lord, what I'm pointing out is that there may be issues that we face two hurdles. One is that we can't be a trade union, and secondly, that the rights dependent on being a trade union are denied to us and to our members. And all I'm saying is that it's no justification for maintaining the distinction that we may have problems at the second stage, either as a union or as members of...
When you say the second stage, what do you mean?
The second stage being surmounting the second hurdle.
Well, what do you mean by the second hurdle?
The second hurdle is that you can't enforce various rights unless you're a member of a trade union. For example, the right against trade union discrimination in Section 146, you've got to demonstrate that it's a trade union.
But the two I see that analytically you're correct, but the justification must be effectively the same, mustn't it? If it's justified not to allow trade unions to be listed with the various consequences that follow, then it will be justified for its members not to have those rights that follow, and vice versa.
Lords, I accept that in almost every case, it's likely that if a union succeeds, if say we succeed in this appeal, then if a foster carer comes to assert a right under Section 146 anti-union discrimination, it's almost certain that the court will say, well, if you're a worker or under an employment relationship for the purpose of forming a trade union, why are we going to erect a barrier against you relying on Section 146 because you haven't got a contract? Of course, that must be right. But analytically, they are two separate.
Well, I accept that, but I thought where you were going, but it doesn't sound as though you were, is to say, well, there may be an interesting justification argument down the line about whether a member who's discriminated against whether a worker without a contract who's discriminated against.
Yes. Sorry, my lord.
For membership of a union which isn't a listed union because the members don't have a contract.
Yes. Lords, I accept that there may be an argument down the line, and it may well be that that's purely hypothetical and...
Okay, well, I've got your point. They're analytically distinct, but you're not making it's not an important part of your submissions that the justification
I'm trying to meet
difference.
the other argument that's against me, which says no point in you having the right to form a trade union because you're barred from these rights anyway because you're not contract workers.
Can we look, as we've got the EAT judgment open, I'm looking at paragraph 125, where they say what foster carers are able to do.
Yes.
Are they right about all that, A to F?
They're right that they can, in some of them, but not in all of them. So, A, they can form a legal entity, which they have done. They can, but they can't form their own trade unions.
Sorry to be boring about that. Have they formed a legal entity? I thought they were going to form a company, but then didn't.
I think that's the case. I don't know how far they got along that course. But
yes.
If they're a company, they can't be a trade union. So they must have abandoned
claimant,
at some stage.
Yes, the claimant is an unincorporated association of six people.
It is.
Yes.
So to the extent that an unincorporated association is a legal entity or an entity known to the law, they do have that freedom. That's true.
Can we, without making value judgments, I appreciate you don't accept the characterisation of the restriction as being relatively limited. Never mind that for the moment. Can you just say whether they're right, the EAT are right about A, B, C, D?
Yes, so they're right about A in the way that I hope I've put it. They're wrong about B, because they can't form a trade union. They can join other...
Oh, well, hang on, they can form a trade union, it just can't be listed.
Well, that's the point we came to, I tried to address yesterday, my lord. They can't join what is known as a trade union in UK law, namely a trade union under Section 1 of the Act. In lay language, of course, a union's a union. People have a general understanding of what that is. I suppose you could take Sidney and Beatrice Webb's definition: the continuous association of wage earners for the purpose of maintaining or improving the condition of their working lives. I think that's 1890.
But that would include an unincorporated association.
Indeed, it would, my lord.
Yeah.
Of every kind.
Or incorporated, which isn't a union.
Yes, and it would include an ad hoc group of workers forming together for a particular demand. Lord, C, they can join other trade unions, that's true. D, can they engage in voluntary collective bargaining and reach collective agreements? Well, again, you've got to use the lay person's understanding of collective bargaining and collective agreements. What they can't do is collective bargaining as defined by the legislation, or collective agreements defined by the legislation, which require a trade union as defined in Section 1. E, they can enjoy many of the benefits associated with listing, but not including compulsory collective bargaining. Well, some benefits, of course, they can enjoy, but other benefits they can't. They can pursue all their stated aims set out in the evidence without listed status. Well, in our submission, that may be factually correct, but it's unreal. It's unreal to imagine that employers are going to negotiate with a body which is not classed as a trade union in law. And it's unreal to imagine that large bodies of foster carers are likely to join them in those circumstances. Lord, there's another point before I pass on in relation to the point that I opened with, and it's this, that so far we've been imagining a union like the GMB with a number of foster carers, a minority of foster carers in its membership, and on the other side the NUPFC with only foster carers in its membership. But it has to be borne in mind that the words wholly or mainly would include a union which has got a large proportion of foster carers. The IWGB is one such union. Foster carers are no doubt in the minority, but they could become in the majority. If they came into the majority of membership, the consequence for those members who are not foster carers, or are foster carers as in the Glasgow and Johnson case who had contracts, would be devastating, because they would lose their trade union rights, because their union would cease to be a trade union under Section 1, whether the certification officer delisted it or not, and they would then lose the protections, the members would lose the protections under Section 137, 146, and so on. The union would lose its access on behalf of workers to Schedule 1 machinery. The union would lose its protection on behalf of workers to take in industrial action.
Just remind me, I'm sure it's in evidence somewhere. How many foster care members does IWGB have?
My lords, I can't tell you. I know it's got 2 branches of them, but I'm not sure the evidence states what the numbers are. We'll have that checked, and I can tell your lordship later on today.
And is the total membership of IWGB about 5,000?
It is, my lord. It's a very small union as unions go. in the modern era.
So far.
Indeed.
Certainly very active in the litigation field.
Very, very active, particularly in your lordship's courts, it seems.
Well, yes, but I've seen other litigation.
Well,
Well,
indeed,
what
and
we
also
discussed so
very active industrially as well.
Yeah.
So, my lords, I was next going to come to the Employment Appeal Tribunal, which deployed the criteria in Bank Mellat and the Treasury, and this was a paragraph 123 on proportionality, and just see how those equations play out. So the four steps are: A, the objective of the measure is sufficiently important to justify the limitation of the protective right. So the objective of the measure is the objective of the restriction on the Article 11 right. Is it sufficiently important that to maintain the distinction between contract and non-contract workers to be justified? And we say that is not sufficiently important. It might be sufficiently important for other purposes, but not for this purpose. B, the measure is rationally connected to the objective. In our submission, the listing of trade unions, or the non-listing of trade unions, is not rationally connected to the objective of maintaining the distinction between the two classes of workers. And the fact that foster carers can join other unions with all the trade union rights that those unions enjoy demonstrates that there's no rational connection. C is a less intrusive measure, could have been used without unacceptably compromising the achievement of the objective. And, my Lord, of course, a less intrusive measure could have been used because it would have been possible to elaborate Section 1 of the Act by saying that foster carers or workers without contracts could be workers for the purposes of Section 1, even if the distinction was desired to be maintained for all other rights under that Act, or indeed in the Employment Relations Act. And finally, balancing the severity of the measure on the rights of the persons to whom it applies against the importance of the objective, to the extent that the measure will contribute to its achievements, the former outweighs the latter. And in our submission, my Lord, the effect on the NUPFC members and their union outweighs ill effects on anyone else if they are permitted to form and list their union. Your Lordships will have noted that the interests of labour and management were taken into account by the Employment Appeal Tribunal at paragraphs 115 and 127. There was no discussion of that issue. It simply said that Parliament had properly balanced those two interests.
Can you explain to us what that means? Who is the management here? Who is the labour? What's the evidence that Parliament has balanced that?
Lord, there's no evidence at all on this issue. It doesn't appear to form part of any of the debate before, in the correspondence before the certification officer, or indeed before the Employment Appeal Tribunal.
There's no evidence on that point before the EAT.
No.
But in proportionality exercises, often evidence is put in front of a court which wasn't in front of Parliament, but that's acceptable.
Yes.
It's an updating exercise. So
Yes.
We may be told otherwise when time comes.
Absolutely, my Lord. I'm perfectly prepared to accept my recollection is at fault, but I don't recall any evidence on the impact on management. In other words, the employers or putative employers' management as a consequence of listing or not listing unions of this kind.
And I'm sorry to go on, what would that mean in principle, management? I mean, does it mean it's irksome to have to negotiate with a union? Is that the impact on the management, or what?
Yes, or it might mean, in a different context, it might mean that management were unable to manage their enterprise properly because of whatever it was that Labour was claiming a right to. So one could see, for example, there might be an argument about entitlement to the right to strike. Now, let's leave aside foster carers, but in another context, because the right to strike would interfere with management's ability to conduct the businesses as they wished.
But might not
that's
a better
this
example
case.
and more is on point be management might say it's very disruptive to have to recognise. I'm not sure this is such a good example, but I'll follow it through so you can say to have to recognise this union because I already recognise another union and I don't want to have small fragmented different forms of representation.
Yes.
And that, of course, Parliament has very carefully considered because Schedule A gives a whole machinery for balancing those things.
Absolutely.
Your point is that that's the kind of exercise that could have been built into the Act, in theory, if there were some justification for different treatment of workers with contracts and workers without.
Yes.
But it isn't. You say not surprising because you can't actually see any rational basis for the distinction in the first place.
Well,
I'm not actually sure that was a good example, but there you are.
Yes, that would be an example of where management got a benefit from not listing
It's a more general, and perhaps the value of the example, if any, is it's an example of the kinds of ways in which forms of union recognition can be disadvantageous to management.
Indeed.
And those have to be balanced, and as it happens, those ones that I've given are balanced in the Schedule A1 machinery.
But my lords, we make 3 points. First of all, Parliament has not conducted such an exercise. Secondly, the Employment Appeal Tribunal didn't conduct such an exercise. And thirdly, it's an exercise which was hopeless in any event because of the fact that foster carers can join other unions and there's no impediment or no disadvantage to management if they do. So why is it justifiable for management to complain if foster carers join one union but not another? Either it's a blanket prohibition that is justifiable or it's not.
But if foster carers do join a general union, say the GMB can't seek to invoke the Schedule A1 machinery for compulsory recognition on behalf of foster carers, can they? If they're not workers.
That's right, my lord.
Yeah.
That's right.
Yeah.
That's your second stage point.
Yes.
Second hurdle point.
But the second stage point applies to foster carers whether they're in their own union or in the GMB. They're still not workers in either case. So the justification has got to be for not listing them in their own union, but allowing them to join a listed union. So
Isn't that double-edged? Isn't that double-edged for you? In the sense, there are no benefits to joining because they can't negotiate for you anyway, because you're without a contract.
Well, my lord, that's a question I hope I tried to address yesterday to demonstrate that there were significant benefits, not overwhelming, of course, but significant benefits in joining. And we contested the Employment Appeal Tribunal's conclusion that the benefits of being listed were insignificant, neither here nor there. But that's a different issue.
I assume a hoped-for result of you winning on this point would then become very difficult for, I suppose, the government or employers, whoever actually had to fight the particular battle, to justify the exclusion of workers without a contract from the benefits of the Schedule A1 machinery.
Certainly, my lord.
Because once the rationale has been defeated at the level of forming a union, it's hard to see why it should be maintained anywhere else.
Absolutely, my lord. I don't deny for a moment that is in a twinkle in the eye of the NUPFC. But there may be justifications for excluding them from that particular right or some other particular rights. And that's an argument that will have to be had when and if the NUPFC or its members seek to rely on one of those other rights. And of course, there are rights which are non-dependent on being a trade union as well, which they may be entitled to if they are workers, notwithstanding they don't have a contract. But your lordships really don't have to address that.
Can I just put down a marker in relation to management? Perhaps it's really for the respondent in due course. I mean, I've read the evidence of Miss Wilson's witness statement. I don't really identify anything which one might describe as management per se. There's a variety of points properly made there, but I don't read it as including anything about management. And I will be interested to hear from the respondent what they say the tribunal meant by that term.
Of course, my lord. So, my lords, the other distinction on which the employment, the other justification on which the EAT relied was, of course, the protection of children. Ms. Krasnow's addressed that, and I won't deal with it further, save to add just, I think, 3 points. First of all, it's a point which Parliament has never addressed. It's part of a balancing exercise that Parliament hasn't addressed. In other words, the relationship between listing and non-listing of a union on the basis of its members having contracts or not having contracts on the one side, and the protection of the interests of children on the other. But, my lord, the second point we make is one that I've made several times this morning, is that if it's justified to deny the listing of a union of foster carers because of its impact on children, then we ask rhetorically, why is it permissible for foster carers to join a union in which they are the minority? It makes no sense to say that it's necessary to protect children from a majority foster carer union, but not from a union in which foster carers are in a minority. Lord, the final point is just to, the final issue is to make 3 short points about reading down. Your lordships will have seen the way that the Employment Appeal Tribunal preferred to read down, if it was necessary to do so. It's paragraph 146 of their decision. We take no issue with that way of doing it. But we do point out that the same effect could be had, or by using the words other persons in an employment relationship in section 1 of the Act. And that would then confine the broadening necessary to comply with Article 11 simply to the definition of a trade union. Lords, Vining shows that it's not, in fact, necessary for a court to find the words which would have the impact desired in the particular Act. Lords, it's, for your lordships note, it's Authorities tab 54 at paragraph 73 to 74. But whichever way your lordships address it, assuming your lordships do find that there's an incompatibility with Article 11 in denying listing to this union. Either way, your lordships can make clear that the broadening of the definition of workers to accommodate Article 11 is simply for the purpose of constituting and listing a trade union. As always, the questions of entitlement to other rights are for another day. Lords, those are the submissions that we desired to make to your lordships, unless there are any questions.
No, thank you very much, Lord Hendy. So it's Mr. Burton next, is that right?
My lord, can I just say before Mr. Burton started, I went over my estimated time yesterday, partly because it's time to go to the authorities and interesting discussions with the lordship.
You mean you're blaming us?
I'm blaming myself, my lord.
That's all right.
I would hate that to cut in any way into Burton's time. We take what you say about the time limit seriously, of course, but if he is committed a little longer than he will be given a strict 6 hours is stuck to,
Well, it's, well, maybe. Let's see how we go. We need to hear very much from the respondents. Yes, now, Mr. Burton, I'm assuming you're wanting to take Lord Hendy's place, though he doesn't seem to want to yield it to you.
Lord Henry's letter, really useful, but I don't want to display it.
Oh, well, I think it's better for us, frankly, if you address this from there. I think we have to take social distancing seriously. Lord Hendy, I think it's all been planned where people can sit, so can you pretend to be Mr. Burton for the time being?
Certainly will. My lords, the initial allocation I think I was given, I think through some negotiation between the parties, as far as I understand it, was an hour. But as I understand it, 6 hours are allocated to the appellant's side. I have something to say about which side I'm on in a minute, but if that's right, I'm not quite sure how much time that leaves.
Well, I'm sorry, I haven't given it any thought.
I mean, needless to say, I'll be as quick as I can.
Of course, and we'll just have to see how we go. I'm afraid I'm not doing the arithmetic in my head, and my lord can correct me, but I would have thought that there was effectively 5 hours yesterday, so on that basis you'd only have
15.
Quarter of an hour. That is obviously too short. I think you should try to finish by 12. I don't think that's going to create any difficulty with Mr. Cooper and Mr. Collins. Let's see how we go.
Very well. I will then largely try to use my written submissions as the source for
It's always a help.
any references. But I'll only take the court to documents if I think it's important that we look at them.
Yes.
But there are a few, and a couple of cases as well, I think we should look at a few passages from it, if I may. As I say, my learned friend, Ms. Krasnow, described the European Children's Rights Units as being on the appellant's side. I mean, that's logical to the extent that if the court accepts my submissions, then that ought to mean that the justification defence advanced by the respondent, at least insofar as it deals with the interests of children, should fail. But I do wish to make it very clear that ECRU, as I'll describe them, have no position on whether or not social workers ought to be able to join listed unions or not. It's not something they've ever had any engagement with. It's not something that forms any part of any sort of policy programme or anything of that kind at all. ECRU's concern is a single one, which is that when the Secretary of State applied to intervene in this case, on the basis that it thought that were there to be any change in status, as described by the Secretary of State, for foster carers, that would be detrimental to the interests of children, it was apparent to ECRU that that submission appeared to be being made without the benefit of what I will describe as a compliant best interests assessment. And that would be one, as I'll come on to develop, that would properly take into account various factors, advantages and disadvantages, etc., and could be demonstrated to be in compliance with the state's international human rights obligations under the UNCRC. And just to foreshadow to some extent my submissions now, the position we find ourselves in is there is still no best interest compliant assessment. Indeed, neither the respondent nor the Secretary of State profess there has been one, either by the certification officer or by the Secretary of State. The respondent's case on Article 3 CRC is that the EAT performed that role. And the EAT is the body that has carried out that compliant assessment. And obviously I'll come on to address that, but for that reason, obviously I need to say something about the EAT's reasoning, as well as say something about the Secretary of State. And I'm alive to the question raised by my lords yesterday, to my learned friend, Ms. Krasnow, about where this procedural duty under Article 3 bites, upon whom, or upon which body, I should say, does it bite? And I'll try to address that point in the course of my submissions. My lords, as I set out in the written submissions, just dealing really with how this point has developed, this is described under relevant background and starts at paragraph 8. As I say, once the human rights arguments were raised by the appellants, the respondent responded by saying, well, any Article 11 interference is justified by the Article 8 rights of children who are being looked after by foster carers. And indeed, the second and third interveners, that's the Secretary of State and the Local Government Association, also joined in that pleaded case. And I've given the references there at paragraph 9. And of course, the Secretary of State and the Local Government Association have provided witness statements in support of their position. And I wonder if we might just take a very quick look at those. The first is the statement of Miss Katie Willison, which is obviously in the supplementary bundle, starting on page 14. And I'm just going to quickly take the court to a couple of paragraphs, starting on page 16. I'm very much just flagging these at the moment, just as issues that are dealt with by Miss Willison. Paragraphs 14 and 15 is recruitment of foster carers. And two important points are made there, that research has shown that word of mouth is a strong driver for recruitment. And second, to paragraph 15, that the majority of those coming forward to do foster care are motivated by altruism. And then just, if I could invite the court just to highlight paragraph 40, payment to foster carers.
So sorry, where were the references about word of mouth and altruism?
Sorry, paragraphs 14 and 15 in Miss... there is an amended version of this statement. I want to make sure we...
No, the answer is I was looking at the wrong witness statement.
Sorry, I apologise. Yeah. Page 16.
Sorry, it's my fault. Yep. Yes, I see, thank you.
Grateful. And the next paragraph I was inviting the court to look at was paragraph 40, where she deals with payment to foster carers. And the court is well aware of what the content of that is, but it's a heading and it's a topic addressed in this statement. And then at paragraphs 45 to 50, we see Miss Willison's comments on recent reviews and fostering better outcomes, where reference is there made to the NARI report, the evidence review conducted by Baginski, the House of Commons Education Select Committee's report and the government's response to that. They are the 4 reports referred to. Paragraphs 46 and 47 don't seem to me to be material for current purposes, but paragraph 48, Ms. Willison cites an extract from page 47 of the NARI report dealing with employment rights. Where NARI is said to acknowledge that employment rights, in general terms, would indisputably bring benefits to foster carers, but would also bring significant obligations to foster carers, more oversight, etc. And then the second part of that extract may be for the courts to determine the employment status of carers, but we believe that were it to be obtained, employment would radically and negatively affect the heart of fostering, would not be in the interest of children in care. And then we see an extract from the DFE report. Well, actually, sorry, it's the DFE, the department's response to the Select Committee's report. And we see again, similarly, a quote from one young man, which is taken to be sort of, as it were, contrary to any suggestion that foster carers should enjoy employment status. And then that extract there, beginning with the words, any change to the employment status of foster carers would have a fundamental impact on the family-natured centre of fostering, bring about significant adjustment to the way the care system is structured, etc. I'm just highlighting that paragraph. I'm going to deal with its comments in a moment, but these are the points that Miss Willison takes in her evidence. Then she says, importantly, at paragraph 50, that whilst the appeal in this case relates specifically to the extension of trade union rights to foster parents, the same principles apply as above. And it is important to point out that none of those 4 reports that we looked at deal with the question of whether or not foster carers ought to be able to join unions, listed or otherwise. That is not a subject matter those reports discuss. And Miss Willison recognises that at paragraph 50. But what does she then say about it? The same basic principles apply as above. For example, if foster parents were to have rights under the 1992 Act, including time off for trade union activities, taking industrial action, or other action short of strike, this would raise serious concerns from both a practical and a policy point of view, and would have a fundamental impact on the family-centred nature of foster care. Crucially, it also brings into question the message that is sent to vulnerable children and young people living in foster care. Many of them understand the financial necessity of payments to foster parents in order to support them to buy clothes and food, etc. But the idea that someone is paid to be interested in them, show them love and affection, can never sit easily. And then the final sentence there, even the perception, for example, that foster parents might be able to undertake industrial action, strike in order to achieve higher pay, could seriously undermine the stability and trust so needed in the relationship. So that is, in essence, really, the Secretary of State's evidence supporting its defence that to allow the appellant or a foster care union to be listed would be contrary to the best interests of children. The way it's pleaded, and I do want to focus a bit on precisely what is said by the Secretary of State and was said to the EAT in particular, keeping in mind it's the EAT who the respondent says ultimately carried out the best interest assessment in this case, is set out in, first of all, paragraph 19 of the Secretary of State's response to the appeal, and I've listed the relevant paragraph, paragraph 10 of my submissions. I wonder if we can just take it from there, please. And
So, which paragraph of your submission?
Paragraph 10.
Yep, thank you.
And I identify 3 reasons why the pleaded case in the Secretary of State is that extending rights as workers under the 1992 Act would radically and negatively affect the heart of fostering. First is the risk to undermining the special link between the foster child and the foster parent. The second is a significant adjustment to the way the care system is structured, increasing the potential for greater use of residential care. Residential care is, i.e., in an institution rather than being in foster care. And then the third one is it would undermine the independence of foster parents from their putative employer. And references there made to Ms. Willison's evidence supporting those propositions. And I've just taken you to that evidence. You've seen the slightly qualified way in which Ms. Willison deals with those reports. And the Local Government Association, as my Lord Justice Bean identified yesterday, also submitted some evidence in this case from Miss Burlington, head of policy, not somebody with experience in foster care, and of course Local Government Association identifies itself as a politically led organisation, but we see at statement in supplementary bundle at S672.
You want to go to that?
If I can ask just to have
No,
a
of
quick
course,
look
not
at
a
that.
problem at all. No. Yep.
Paragraph 4, my lords, is interesting because this is the only evidence at all that deals specifically with the question of collective bargaining, which, as we are increasingly learning in this case, is critical because, as I'll come on to demonstrate, I hope, that is the principal basis upon which the EAT found there was an interference with Article 11. It's the denial of compulsory collective bargaining. And what Ms. Burlington says is that the LGA support the role of collective bargaining and the rights of individuals to join trade unions to protect their rights, but then says this appeal has potentially significant wider implications. And in support of that, effectively, they repeat the same point from the NERI report. Then at paragraph 10, there's a point made that, well, if they're given worker status, they might claim other rights. And this could have significant financial implications for councils. Now, of course, that's not part of the justification that's been put forward. It's important that we understand what the LGA's position is. And the point about cost is made again at paragraph 12. So support for collective bargaining, and then otherwise simply endorsing the point made in the NERI report. That's the summation of that evidence. So it was looking at that situation that motivated ECRU to intervene. And as I say at paragraph 12, its intervention was really designed to stress not that, oh, you've got this wrong, so much as there are other reasons why children might benefit. It was more that you haven't done the sort of assessment that international law and indeed through Strasbourg now our domestic law would require you to undertake, which properly weighs the balance of interests and positive potential implications of listing the foster care trade union as against the disadvantages, because effectively the evidence in ECRU's mind was principally, if not solely, focused on the negative consequences. And I do want to say something a little bit about those submissions that were put forward by ECRU to the EAT before we then look a little bit at some of the references that ECRU used to make good its proposition. And the first very important one is it's not just the case that ECRU doesn't have a sort of, as it were, position on whether or not foster carers should be entitled to join a listed trade union. It's that they didn't profess to have put forward evidence, in fact they weren't allowed to put any evidence forward, to try and counterbalance what ECRU's view is, which is that the evidence of Secretary of State and to a degree the LGA is somewhat biased. Not biased is not the correct term, but is unbalanced in the sense that it only focused on the potential negatives and didn't look at any potential positives. And so it would be wrong to treat ECRU's evidence, because there wasn't any evidence, but its submissions as being, as it were, the totality of the evidence that might be available that would indicate the positive effects of listing. And indeed, ECRU say so in terms in those submissions. Its footnote 1 to page 1 is that there is a significant body of additional evidence.
Sorry, where?
Sorry, I'm looking at 361. I wasn't actually going to take court to it, but we can.
Well,
That's
we're now,
bundle
okay, well, we've
361.
started, so let's do it, yeah.
Page 361.
What, in which bundle?
Core
sorry?
bundle.
The core. Yeah. Our core doesn't have a 3. 320 to 4630 intentionally blank, it says.
The bundles were updated, I think, to include some documents, including...
Wait, I think I've got it, however.
Is this the one that was put in with your
356 is the
skeleton
first
argument.
page.
Well, it was attached to your skeleton argument.
Section-
No, there are a couple of pages of evidence that also didn't make their way into the supplementary.
Well, where were you to find them?
Well, as I understand it, they were all sent with modified bundles, and I don't know if we have any.
Well, you weren't going to take
Is this 3 pages headed section 12 conclusions?
No, I'm glad the court have those, but that's not what I'm referring to. So what I'm referring to is the submissions that were made to the EAT, which I'm referring to here, obviously, in my submissions to this.
Well, okay, no, I understand. Since you weren't going to take us to the document anyway, just tell us the substantive point you want to make. But I think, can you either send us an email showing where we should have got them, or if we haven't got them, attach them?
Certainly, Mo, yes.
And if you can give us the reference as you go along so we can cross-check that.
Absolutely. In paragraph 12 of my Court of Appeal submission, I make 3 points about the submissions that were made below by ECRU,
Yeah.
and they are referenced by paragraph numbers.
Right. Oh, I see. Well,
And you
okay,
have
well, that's
those.
probably all we need, but let's have the document as well.
Indeed, but the additional point I wanted to make that isn't referenced here
Yeah.
is that, as I say, ECRU didn't profess to have carried out its own version, if you like, of an Article 3 compliance assessment. And it wasn't given the opportunity to deduce evidence, but it makes reference in footnote 1 on page 361 to the fact that there is evidence available on some of these points, and that had the Secretary of State conducted what in its submission would have been a proper compliant best interest assessment, that evidence would have been considered, at least something of its gist would have been considered. And by way of an example, at paragraph 37, page 365, ECRU said in particular that there would be evidence available demonstrating the positive correlation between union membership and worker retention and recruitment and well-being. And the reason why they make that point specifically is because what ECRU were able to demonstrate, and I'll take the court to some of the documents at the moment, is there is a very significant problem in the foster care system around recruitment and retention, which even the evidence that was before, or in the reports before the Secretary of State, is shown to be connected to pay and conditions and the extent to which foster carers are unhappy with their pay and conditions. So in very simple terms, if the problem of recruitment and retention might be addressed by allowing foster carers to join unions and improve their conditions, then that obviously would have a positive impact on the children who are either being looked after or may be looked after in the future by foster care. And that is one of the sorts of benefits that in ECRU's submission, a compliant best interest assessment would have factored in.
Your submission boils down to this: the EAT erred in accepting the respondent's evidence for objective justification when, one, the evidence wasn't adequate, and two, you pointed out that it wasn't adequate and didn't meet minimum standards.
Absolutely.
That's effectively your submission.
Yes, and the mistake the EAT made, or one of the mistakes that I would say the EAT made, is it treated ECRU's submissions as being the body of evidence that showed the positive or potential positive impacts of listing, and purported to weigh that, if it did any kind of weighing, purported to weigh that against what the Secretary of State and the respondent were saying about the negative consequences. Now, that's not good enough, for the very clear reasons pointed out by ECRU in its submissions. It didn't have permission to reduce that evidence. It was just trying to make good its fundamental point, which is you should have conducted a best interest assessment here because the answer is not obvious. Very far from obvious, in fact.
You might say that the points that you make in 12.2 of the skeleton are not surprising. That if foster carers were allowed to join trade unions that could conduct collective bargaining on their behalf, and thus increase the allowances, fees, whatever it is. That would, you say, tend to encourage a wider pool of people to apply to become foster carers.
Yes.
And that might well be in the best interests of children.
Yes.
Whereas the Secretary of State says if foster carers had rights to holidays and so on, that would have detrimental. And nobody seems to have balanced those two factors against one another. The interests of children point is thought to be all one way. Sir Martin Neri and Mr. Owers and others say that it would be against the best interests of children for the reasons they give, and there's no balancing of the contrary.
No, I mean, it's fair to say that the Neri report, even on the basis of what it did purport to consider, which was in a very general sense employment right or employment status, I'm not quite sure is really the same as the issue that's being contemplated here. And I'll come on to develop that a little bit further on. But it's certainly clear that none of those reports considered what the positive impacts of collective bargaining or unionisation in a broader sense what might be and what impact it might have. And certainly Secretary of State hasn't done that, and neither does the EAT. And therefore the defence, insofar as it relies on best interests of children, ought to fail. That is in essence my submission. But might I then just, the page references that I have listed there, it's paragraph 12, little 2. Can I just say a little bit about those? The first is the documents that were appended to the skeleton and unfortunately didn't make their way to the supplementary bundle are the conclusions attached to the executive summary of the Baginski evidence review. And that's the reference at 240. And it's noteworthy because of what the Baginski review identifies as the biggest challenge for foster care is how to secure the future recruitment and retention of enough high-quality foster carers. It is not a new issue, but our children's system will be jeopardised if we fail to do so. And then what we see, and I'm just going to give the court the references, they are the ones in paragraph 12.2, supplementary bundle 97. Can I just ask that to be modified to extend to page 99? Please read on to page 99.
Yeah.
109 to 111, 113 to 117. That's all Baginski. And then 447 to 449 is the House of Commons Select Committee report. And then the references that are 700 are to the, get the name for it, the State of the Nation Foster Care Full Report, which was by the Foster Carers Association, Fostering Network.
Fostering networks, yes.
And there, the point is made very explicitly of a large survey of foster carers, that the main thing that would improve foster caring is improved paying conditions. And I took you to those passages in Miss Willison's report that dealt with recruitment and pay, just to demonstrate the fact that nowhere in that statement, in her evidence, did she say anything about the problem of recruitment or retention being a big problem in foster care, or anything about unhappiness about pay, or anything of that kind. Indeed, even Neri identified a problem with pay. say, which was that a very significant number of foster carers were not even getting the statutory minimum they were entitled to. And of course, Mary said they ought to get that, and doubtless the government feels the same way about it. This is about local authorities not even meeting some of those basic criteria. So there are real problems here around pay commission. And what the Baginski report in particular also does is draw the link on those page references I've given between deficiencies in the stock of foster care, stock's not the right word, but in the body of foster carers, and impact on children. Now, it doesn't elaborate on that in great detail. It's perhaps obvious. But particular reference is made to children who have very challenging, high-level needs, not being able to get the high-quality foster care they need. And the point is hinted at in the conclusion there too. So there is a logical, as it were, set of arguments there that would have been available and should have been available and should have been included in any best interest assessment. That doesn't necessarily mean that the argument wouldn't have still come down on the side of saying that unions, foster carers shouldn't be entitled to join this. That's not my case. My case is that that hasn't been properly analysed. And just to finish then about what the pleaded case was before the Secretary of State, before the EAT, I apologise. Can I ask the Court to look back to paragraph 13 of my submission? Because I identified the three consequences that were said to justify the Secretary of State's conclusion that listing would radically impact the heart of fostering. And there's a fourth one that is then mentioned in the skeleton argument below. We don't have the skeleton argument of the Secretary of State below, but I don't think anything arises from that. I've quoted there the relevant paragraph 109, where the unquantifiable effects of listing are mentioned. And this is where I'm going to call this the sort of perception argument, that there would be some change in the perception of foster carers by the children they looked after. So that's the fourth reason. And then at paragraph 14, again I'm citing from the skeleton argument below, the Secretary of State says, paragraph 125 of that skeleton, and I'm just going to...
Sorry, just before you go on, behind the perception argument,
yeah.
What is the evidence? Does it come from NARI, or is there any survey evidence, or what is it?
Well, I was going to there is one quote in the NARI report from a child.
I think that's one we've seen.
What I was going to take the Court to in due course is that there are other quotes from other children who diametrically go the other way on perception and fully endorse the idea that foster carers should be paid. And there are other quotes from foster care children saying the problem is their foster carers don't have enough money. So there are other quotes that might have, if one had been looking at it in a slightly more impartial way, I would submit, have made the perception argument less easy.
I mean, I can understand that, but in terms of evidence or probative weight of evidence, one might be looking for something quantitative or qualitative, some sort of survey evidence. There's lots of ways of measuring this. There's nothing like that. It's just, if you like, pieces, I was going to call them snippets, that's unfair, but pieces of evidence from individuals which have been collected together.
Yes. Well, on that, there is just Miss Willison's view, I think, as I understand it, as expressed in her statement.
I suppose there's two questions. One is what evidence was before the EAT?
Yes.
But a question is what evidence is there, as it were, out there that could have been produced if they had done a different kind of exercise? I'm not asking you to say anything that isn't in your submissions, but
yes,
because this is, if it's fundamental to your case that there should have been a full holistic assessment, it would help me to have some sort of idea of what kind of exercise it is said should be being done and by whom. Is the Secretary of State meant to go out and, obtain survey evidence? And I don't know quite what form such evidence would take.
Well, I was going to address the Court on this point.
Okay, well, do it when you get there.
I think that might be better just because of time. The point I'm making here about what comes out of paragraph 14, and particularly paragraph 14 of my submission, paragraph 125 of Secretary of State's skeleton argument below, is that it is said that the considered view of the Secretary of State, following the extensive reviews noted above, is that identifying foster carers as workers of the local authority and extending rights of workers generally for foster carers would not promote stability and continuity and would fundamentally damage the family nature of foster caring, etc. And repeats the three arguments that we've already looked at. But what's, in my submission, noteworthy is that, first of all, there's a considered view, so described, which appears to have been formulated more recently than, for example, when the 1992 Act was enacted, which has some bearing, it might be said, on the issue that's before this court, but only in a limited way, and that's actually identified by the Secretary of State in paragraph 126 of the skeleton argument, which I've quoted at paragraph 15, which, again, is important for focus, because the Secretary of State says, of course, the current case is not concerned with the wider question of the extension of worker status to foster carers. Submissions of the Secretary of State addresses the question whether the application of the 1992 Act to workers, but not foster carers, results in a violation.
I think useful, I think, to say now that I, at least, I hope I speak, whether I speak for my colleagues or not, would like us to be supplied for completeness with the skeleton arguments for the final hearing, which were originally intended to be in the bundle, but were taken out. So not just the ones that Mr. Burton has been referred to, but I think we should have the totality. Thank you.
Great. And my lords, just to finish on background, I'm just highlighting the fact that obviously we've looked at what the relevant ground of appeal was yesterday in my lord's questions to my learned friend Ms. Krasnow. It's ground 2E, core bundle page 39. And of course, it's just worth noting at this stage that the respondent has filed a respondent's notice, paragraph 7 of which is the pages core bundle 169, 170, that seeks to reinforce, as it were, the EAT's conclusions by reference to Article 3 UNCRC. Now, my lords, the submissions of ECRU are then divided into three parts. One, the reason why Article 3 is relevant to this appeal. The second, the relevant procedural and substantive legal obligations attached to Article 3. And then the extent to which those obligations have been met in this case. On the first of those, whether or not Article 3 is a relevant issue, I hope I don't need to trouble the court on that, because one, the respondent, as I've just said, has made sure it is, and two, it flows very directly from the fact that the respondent and the Secretary of State, and indeed the LGA for that matter, has pleaded the case on the basis that the Article 11 interference is justified by reference to the Article 8 rights of the children. If that's right, then it's incontrovertible that the Article 8 rights of those children must be applied by reference to the criteria in Article 3. And I hope I don't need to trouble the court too much with that. But if there's any doubt about that, the submissions are then set out in paragraphs 19 and 20. I mean, in very, very...
If your time is short, and if you're really saying you don't believe it to be an issue, I wouldn't spend time on summarising what's very clearly set out here.
Grateful. Well, then, just moving on then to the relevant content of the duty. And if I could ask the court to turn to paragraphs 21 and 22.
Perhaps I should just ask this for completeness. We're familiar in the immigration field with Article 3 being in effect incorporated by Section 55 of
yes.
whatever Act it is. There's no equivalent direct statutory incorporation here, but you say it doesn't matter because this or other route
Yeah,
applies.
exactly. I mean,
Yep,
there
okay.
is a point made in little paragraph 20, little 4 about that, and the extent to which there are relevant statutory duties here that even the respondent says are sort of, if not directly engaged, they're peripherally engaged, all of which carry sort of the spirit, if not the precise wording, is the language used in the cases. And they would be another means by which the Article 3 jurisprudence would be transposed here. But there is no direct duty in the same way as Section 55 is applied in the immigration context.
Sorry, I distracted you. You were about to go on to
So
the
paragraph
substantive
22,
points.
so what is the content of this duty? And I think the first and most important point to make, of course, is that it's much more than a restatement of the ordinary, material consideration duty or relevant consideration duty. And indeed, I've cited there the passage, and sadly, the late Lord Kerr, in ZH Tanzania, which is kind of the seminal description of what I will describe and is described as the substantive duty, which is that there is a particular weight to be attached to the best interest of children.
Well, again, this is very familiar to, I think, all
Most
members of the
grateful.
court from the immigration context, and unless there are particular points you want to highlight, I wouldn't have thought it was an area you needed to emphasise.
Well, the parts I would like to highlight are the ones at paragraph 22, which come from the speech of Lord Carnworth in the case of SG in the Secretary of State for Work and Pensions, often known as Benefit Cap number 1, where we see really a full development of the content of the right as it applies to policies which affect children generally. So unlike sometimes in the immigration context when you're dealing with a single child or a single family, this is dealing with the context of a policy which affects children more generally. And in particular, Lord Carnworth's endorsement as the most authoritative guidance, the passages from the UN Committee on the Rights of the Child, General Comment number 14. And at paragraph 106, Lord Carnworth explains what two of those are. It's two aspects of a sort of tripart or threefold concept, as he describes it. The first is the substantive right, which is the one I referred to a moment ago about the weight that should be attributed to the best interest of children. And then the second is the rule of procedure. And the rule of procedure effectively requires it to be an evaluation of the possible impacts of a measure, positive and negative, before there is any determination of the best interests. And the language is used somewhat interchangeably in the cases and in the general comment, but effectively it comes down to this, that before you can weigh the best interest of the child as a primary consideration, you need to have evaluated them properly, which means you need to have assessed them and then determined them. And in the course of doing that, you must, of course, and this is not an unusual or in any way an unexpected concept, you must be impartial, evidence-based, and look at the positives and the negatives. And indeed, as is said in that citation by Lord Carnworth, you must be able to demonstrate you have explicitly taken the right into account. And my lords, in relation to that authoritative guidance from the General Comment 14, I would just ask the Court to also note the passages I've cited at paragraph 24, and in particular paragraphs 46 and 47 from the General Comment, where we see a little bit more elaboration of that two-step process. And at paragraph 47, assessment and determination of the child's best interest are two steps to be followed when required to make a decision. The best interest assessment consists in evaluating and balancing all the elements necessary to make a decision in a specific situation, a specific child or a group of children. The best interest determination describes a formal process with strict procedural safeguards designed to determine the child's best interest on the basis of the best interest assessment. And the general comment also speaks to the need to have child rights impact assessments. And at paragraph 25, I just note the fact that, in fact, the DfE has adopted a children's rights impact assessment framework for its policy decisions, but it didn't utilise that framework for the benefits of this case, or indeed when it formulated that considered opinion, as it described it, about what the impacts would be of the broader question of employment rights being granted to foster carers.
Do we have framework in the evidence? Presumably not, from what you've said. Where do we find it?
It's supplementary 392, I believe. No, it isn't. It's not coming up. It ought to have been. There was a bit of a culling of the supplementary bundle to get it under the
Yes, I think, well, let's not waste time on it. Maybe the parties rolled over perfectly properly. They were asked by the masters to justify the length of the bundle. It might have been better to justify a longer bundle than to take out stuff you actually wanted to refer to.
I mean,
but don't worry, let's not spend time on that now. I think we ought to see the impact assessment. Again, I don't know at the end of the day how important the precise language will be, but
I don't say it is, actually, particularly. I mean,
never mind. Can we see it?
Yes, certainly.
Yep.
So I'm just going to develop a little bit more, but not much, about the content of the rights. The case I mentioned a moment ago is the SG case. And I just want to make a couple of points about that, because I can see there's an issue that's arisen between the appellant and the respondent about it, and I need to, if I can, just deal with that. It is, as I say, the first benefit cap case. Lord Carnworth sets out the principles there, and then if I can just give the court the references, because of time, at paragraphs 104, 109 to 112, and 122 and 128, we see a very good example of what the kind of careful analysis ought to be when the court is looking at a matter which is said to be either in the best interest of children or, as in that case, was ultimately found to be not in the best interest of the children, but nevertheless favoured by the government. Because, of course, the content of the assessment process or the evaluation process is the same, whether or not the public authority is saying its particular measure is in accordance with the best interest of the children or is not in accordance with the best interest of children, but they are nevertheless being outweighed by other countervailing factors. The manner in which you approach the content and the determination of the best interest has to be equally rigorous in each case. But why I'm taking you or giving you those references is to give you a real example of the kind of close scrutiny that the court will apply when looking at a measure which is said to affect children and therefore engage Article 3. And Lord Carnworth's view was that the Secretary of State had not discharged the obligation to demonstrate the benefit cap was consistent with his Article 3 obligations. And Lord Kerr at paragraph 247 and Lady Hale at paragraph 225 both agreed with him in that analysis. Now, it's right to say, however, that the majority of the court in that case, including Lord Carnworth, ultimately found that the fact there had been a breach of Article 3 wasn't relevant to the issue that had to be decided in that case, which was whether or not the discrimination between men and women, indirect discrimination between men and women, that arose because of the impact of the benefit cap was justified. In essence, because whether the child was a child of a woman or a man, the impact was the same, and therefore it wasn't a relevant consideration for the purposes of the Article 14 determination.
Now, Mr. Burton, I said 12. We're at 12. How much longer do you wish to be?
15 minutes?
Okay,
Is that okay?
it is.
I'm most grateful. So I'm just going to finish with some references, if I can, in the case law, because you do need them in my submission. The first is the next case of Matheson versus Secretary of State for Work and Pensions.
Are these references not in your...
This one is not. That's why I'm
Okay.
giving it to you now. So that is Authorities Bundle 48, paragraphs 38 to 41. Another example where Secretary of State was found to have not complied, actually in relation to regulations that were at that point sort of 20 years old. So that's interesting in its own right, or 15 years old. But the important point of Matheson is the majority of the Supreme Court there endorsed Lord Carnwath's analysis in SG about the authoritative guidance from the general comment. And that's important because, of course, I'm relying on that guidance in this case as being what one needs to see in terms of a compliant assessment. And then you've got benefit cap number 2, which is the DADS case, Secretary of State for Work and Pensions, Authorities Bundle 65, where Lord Wilson gave the lead speech, and his deployment of the relevant principles, both in relation to Article 3 and more generally, is supported by all of the other Supreme Court justices, references, paragraphs 124, 132, 158. And at paragraphs 67 to 69 of Lord Wilson's speech, he again reinforces the point about the general comment and the guidance. He also, if the court might find it useful, explains the decision-making in benefit cap number 1 as to how it dealt with Article 3. It's quite difficult sometimes to follow the judgments in benefit cap number 1. I think that's a general consensus at the bar. But they're nicely summarised by both Lord Wilson and Lord Carnwath in benefit cap number 2. And my suggestion would be go there just to find out what was said. Lord Carnwath, his description is at paragraph 94. And in paragraph 79 to 88, Lord Wilson explains why, in that case, in fact, the court found that Article 3 had been complied with by the Secretary of State. And there's an interesting comparison between the two benefit cap cases and the difference between the type of evidence that was adduced by the Secretary of State second time around and how they achieved compliance. And it really does demonstrate, in my submission, why it is said by Lord Carnwath, paragraph 122 in SG, that this really is very far away from being a kind of standard material consideration type of public law obligation. It's something much more substantive than that. And that, in my submission, has some relevance to how the EAT dealt with the issue. The final point I need to take you to on this is Lord Wilson's paragraph 78, which I have repeated
in DS.
In DS, I do apologise, sorry. Which I have repeated in my submissions at paragraph 31. If I could ask the court just to look at that. Now, this is a case in which the manifestly without reasonable foundation test was applied, which I understand may be a dispute between the parties in this case about whether it applies. But even when it applies, Lord Wilson's statement there is, as it were, the final word about how a failure by government to comply with Article 3 impacts upon the assessment of justification of a substantive convention right, or indeed Article 14, it doesn't matter. Do my lords have that?
Yes, resume. I definitely read it.
So, my lords, in the 10 minutes I have left, under the primary decision makers that I've described in paragraphs 26, indeed through to 31, I deal with the respondent and the Secretary of State and why they haven't complied with Article 3, but I think that's common ground. I don't believe them to be suggesting that they did comply. So if I can then just turn quickly to the decision of the EAT. which begins at paragraph 33. First of all, as we've already seen in Ms. Krasnow's submissions yesterday, at paragraph 46, in the context of deciding whether or not foster carers are workers pursuant to a contract, references there made to the evidence, and I've highlighted there in bold the passage I would invite the court to read. And then over at 47, again I've done the same. And we see the slightly ambiguous comment, we are not in a position to reach any conclusion as to whether worker status would be beneficial or harmful to the special relationship between foster care and looked after child. That is not what this appeal is about. Which, to some extent, the appeal was about that, because, of course, the Secretary of State was advancing the best interest of children as justification for the Article 11 interference. So what did the EAT mean by saying this is not what this appeal is about? It seems to me, but I'm doing my best to interpret it, what the EAT were effectively saying there is this case isn't actually about extending full worker status to foster carers. But in any way, or whichever way we look at it, there's clearly no finding by the EAT that extending worker status through the 1992 Act or more generally would have a negative impact on the special relationship, which you will recall is one of the four propositions put forward by Secretary of State as in support of justification of defence. And then at paragraph 35, I deal with what I say is very important, which is the manner in which the EAT dealt with interference. Now, I know the other parties have different points to make about whether the EAT got this right, but the key points I just want to make clear now are...
So sorry, which paragraph?
Oh, sorry, paragraph 35.
35, sorry, it is my post just catching up. Yeah.
So very much looking, as the EAT described it, as the impugned act, which is the refusal to list. Quickly as I can, one, that because it's only going to be a contract personally to provide services rather than an employment contract, the TUPE rights of negotiation redundancies don't flow, so they're not rights that would be lost. Industrial action is considered to be extremely unlikely as a question of fact. Collective bargaining, however, would be of some benefit to foster carers, even though they don't have contracts. The benefit that would be lost is the right to apply for mandatory collective bargaining, and that is a right with tangible benefits for foster carers.
Well, we've been through this, haven't we, Mr. Burton? Up to paragraph 39 of your schedule, and you're helpfully summarising what the EAT said.
It's great. I just want to make clear what it is the EAT were seeking to justify. Okay, so then the time I have left are the criticisms I make then of the EAT's conclusions, and they begin at paragraph 42, and they carry through to 50, and I won't read all of those out there.
Can I be clear about this, though?
Yes.
It's not part of your submission that it would not be open, the EAT, that it would not be, put another way, if the EAT had done the job you say it should have done, that would satisfy the obligations under Article 3, because the court effectively can do the job which might otherwise have been done by the Secretary of State.
Yeah, in principle that is theoretically possible.
You say theoretically possible. It's actually quite important in a case of this sort, isn't it, perhaps, because you can get a point like this, where I don't think, at the time the 1992 Act was passed, nobody thought specifically about the impact on foster carers. That's pretty clear.
Yeah, well, Parliament obviously doesn't have a say on this, and we're not being asked to defer to the position that Parliament has taken, but we very much are being asked to defer to a position that the Secretary of State has taken. And the Secretary of State hasn't advanced a best interest compliance assessment.
Yes, but even there, the court can say, nevertheless, the conclusion arrived at is one that is justifiable having regard to the best interest of the children.
Well, the court...
I think you're agreeing with me. The only point I'm trying to make is the court can do the job, but you say it didn't do so here. Is that right?
And my submission will go somewhat further and say it was actually essentially impossible for the AT to do it, because it didn't have the evidence before that would allow it to do it.
Well, all right, but if the right evidence had been put, there's no institutional bar on the court being the right person to do the job.
But there is no single example in any of the case law of the courts ever having actually done that. This would be the first time that the court would say, well, the relevant public authority or governmental body hasn't done it, but the court is able to do it instead. Not in relation to a policy matter which has broader impact beyond the interest of the specific child that might be
yes, but it's actually quite important, isn't it, as a matter of principle, because it will quite often be the case, and this case may be an example, that the point isn't, as it were, seen coming until the moment that litigation starts. And if the decision taker, the state, then does an ex post facto justification,
that's absolutely fine. There's nothing that happens all the time. Article 14 cases, day in and day out. And there are all sorts
so the court will have a different role depending on how the Secretary of State has chosen to if the Secretary of State has done a job which is procedurally satisfactory,
yes,
the court's role will be restricted to a reviewing role, effectively saying, is this an assessment which has been fairly reached, in which case I won't interfere.
That's the DA case, that's what they decided in DA.
But if the view is taken that the Secretary of State has not done a proper job, then if we were in a judicial review context, one would send it back.
Absolutely.
Have another go. That's rather difficult in a context like the present, where the issue comes up, as it happens in the AT, but one can imagine other situations where it comes up in the course of ordinary inter-parties litigation. There, it's not procedurally easy or conceptually easy for the court to say, I'm determining a question between these individual parties. Secretary of State isn't a party which said I've allowed them to intervene. It's not appropriate to say go away and Secretary of State and do the job again, and then the parties can come back when you've done it.
I think one of the differences here, however, is the Secretary of State has decided to intervene in a case because of a position it had already taken, or he had already taken, which he felt was incompatible with the possible consequences of this case. Now, having decided to advance that, it's got to be a properly formulated opinion.
Well, I dare say, but I'm just trying to see how this is supposed to work conceptually in the context of litigation between individuals. Which for this purpose the union is. And really, in such a case, where the court takes the view that the Secretary of State hasn't done the job, or hasn't done a proper job, the moment there isn't the usual mechanism of a judicial review where you quash the decision and say go away and take it again. Really, the court has got to do the job itself. But that's unsatisfactory too, because if it hasn't got the right materials in front of it, effectively a public law question is being decided on the basis of inadequate information in the context of private law litigation.
Yes, it's private law litigation, but being resolved by reference to the convention rights, which obviously are sort of quasi-public in that sense. And of course, the obligation to justify rests on the respondent, and if a limb of that justification defence is not established through non-compliance, exactly as Lord Wilson says in paragraph 78 of DA, then the defence fails insofar as it relies on that limb.
But defence of what? I mean, like my lord, I'm struggling to grasp this conceptually. Suppose you're right that the Secretary of State has at no stage conducted a balanced impact balanced assessment of the impact of the exclusion of the claimants from listed trade union status on children.
Yeah.
What consequence do you say follows from that?
Just as Lord Wilson identifies, part of the justification defence falls away even if you apply a manifest test.
Sorry, but I didn't put it clearly.
My-
Justification of what? In the benefit cap cases, the government's decision that was under scrutiny was a decision. Benefit cap number 1, it was a statutory instrument.
Yeah.
Can't remember about number 2, but a decision to limit benefits to £X per week. But what is the decision here which you say is unlawful? And,
Well-
when was it taken?
Well, I think that's, if I may say so, I think that's actually asking a slightly different question, which is, did the procedural obligation sort of bite at any point? Was there any action on which it could bite, perhaps? Because in very simple terms, what we do, the consequence of there not being a capacity on the part of the court to either endorse a compliance assessment or reach its own one, is to score out best interest of children under the justification defence and proceed to determine Article 11 justification based on the first of the two identified legitimate aims. That's what the court ought to do, if it can't do either of the other things, which is, as I say, endorse an existing assessment or formulate its own. A second question, which perhaps I haven't really dealt with, is, well, did any of these procedural obligations really bite when all the Secretary of State is doing is defending a piece of litigation? And I say litigation. Because in one view, that is, if I understand my Lord Justice Bean's question, I'm being asked really, well, what are you impugning as being an unlawful act by the Secretary of State? But that's not what I'm doing. What I'm seeking to show is that insofar as the Secretary of State wishes to rely upon a considered opinion and ask this court to defer to that considered opinion, that it would not be justified to allow trade unions, this trade union, to be listed because of the impact on children.
But, I mean, in this case, at least, as it happens, the defendant is a public body, the certification officer.
Yes.
But analogous questions could arise in completely private law, between litigation between a foster carer and an employer, say a fostering agency.
Yeah.
And say they had applied for protection against trade union discrimination, say, and it said, well, you haven't got this. And that it would at some point be necessary to see whether the exclusion of foster carers from full employment rights was compliant with Article 3. I know this case has come up by a particular route where this problem isn't quite so acute, but it could be. Now, in those circumstances, what's the employer to do? How is the employer to access the justification for simply a piece of legislation with which the employer has had nothing to do?
Well, I mean, that would depend on the tribunal in respect of which they are appearing, it seems to me, and whether or not that tribunal would, first of all, be able would be under some obligation to apply convention rights. So, so in the context of, in a different context, in the context of property, for example, if there's a dispute between a private landlord and a private tenant, and the tenant wishes to invoke convention rights, the courts are very clear that you basically can't, because there's no public authority upon which to criticise for the breach. In other words, there's no horizontal impact. So if I've understood the question, it seems to me that it's not a scenario that's really likely to arise. I mean, it's arisen here because the appellant says that it's the statute that prevents the certification officer effectively from listing the appellant, and that's a breach of the convention. I mean, that doesn't seem to have been the reason why the Secretary of State decided to intervene. It wasn't because of the risks of the legislation so much as the concern it had about the interest of children. But
I assume the Secretary of State intervened. I forget what Secretary of State it is, I ought to know. Associate for Education, yes.
Well, we do
Yes,
have-
well, I don't know whether Secretary we'll have
it's in the
we'll-
material.
we'll-
It's in the core bundle.
It's a slightly odd set of facts.
well, we'll deal with that. We'll deal with that later. But I'm just interested in the points that Mr. Burton can help us on. Perhaps we've explored them about as far as we can.
Yeah, I fear we might be. I mean, there is perhaps a practical problem to some extent, which arises here, that you've got an older piece of legislation, and you've got the court being asked to determine an issue between the parties, which requires consideration of Article 11, and the Secretary of State has decided that it takes the view that any interference is not justified for the reasons it says. But ultimately, all this court's got to do is test those reasons against the relevant threshold. And if it can't accept one of them because it's been formulated in contravention of a relevant obligation contained under Article 8 or 11, depending on how you look at it, then I think the tribunal simply has to reject that limb of the defence. It's really as simple as that. And if insofar as, even if you accept the logic of that position, it's not tantamount to saying the Secretary of State had to go out and conduct some big survey and work it all out. They just, at the very least, needed to present a compliant assessment, which is, on the facts, realistic, but deals with all relevant matters, and they don't.
If the AT had so found that the respondent's evidence, Secretary of State's evidence, was inadequate,
Yeah.
and also because this was an appeal against the CO's decision, ergo, the evidence in the decision was inadequate because there'd been no proper assessment by the decision maker.
Yes.
Would the EAT then have simply quashed the decision and remitted it to the CO? They may have said, well, we can't decide it, but we can simply set aside the decision of the certification officer and require that exercise to be done again on proper evidence.
I see. Well, the whole discussion there about remedy, which is important, because, of course, frequently what happens in this sort of scenario, my Lord Justice Underhill was asking me, is the courts simply make declarations. They wouldn't, for example, read down the provision in this case. They would make a declaration that's incompatible with Article 11 and require the...
Well, if that's not open to an employment tribunal, or indeed the employment appeal tribunal.
Well, that's interesting.
Certainly not to the certification officer.
Yes, no, I appreciate that the certification offer is a problem. I mean, I think there's only so far I can really go on the question of remedy, because it's not something that...
Yeah, but remedy is also plugged into the question of, conceptually, how your arguments fit in to the question of the lawfulness of the decision that the certification officer took. I think I see what your answer is. I'm just not sure to
Well, if I
think
can...
about it further.
Yeah, I'm not sure I can. I mean,
Suppose the Secretary of State hadn't intervened.
Yes.
How would the certification officer have advanced a justification of what is effectively the state of the 1992 Act as it applies to foster carers?
What, in the context of an Article 11 argument having been raised by the appellant?
Yes.
Well, the certification officer presumably would be able to reach his or her own conclusion about whether or not there's been an interference with Article 11 and whether or not it's justified for whichever reasons.
But in order to do that, if you're right, the certification officer would have had to carry out an investigation of the impact of non-union recognition on the best interests of children. That seems a slightly unrealistic task.
Well, no, actually, they wouldn't have done, because why would the certification officer have been made alive to that point? I mean, it's the Secretary of State who's introduced this as saying...
Yes, but the certification officer has to work out what the justification is for the legislation which he is, on the face of it, obliged to apply. He can't apply it if it is, or he may have to apply it contrary to its apparent meaning, as long as Section 3 is open to him.
Yes.
Unless he finds that it is justified, and it may be said this is bad. But suppose it had been said in terms, this is bad for children because it's good for.
Said by whom?
The National Union, by the claimant.
had said that not being unionised is bad for children.
Yes, exactly.
And would be wishing to advance a case that it was positively in children's best interest.
Exactly.
And how would the certification officer deal with that?
Yes.
I think. I mean, this is, I think, slightly out of my terrain because I'm not familiar with how disputes before the certification officer are normally decided. I don't know whether or not they have powers to sort of call upon.
No, it's a more general question, though, isn't it, about how the Article 3 obligations are to be given effect to in the context of private litigation.
Yes.
All the cases which we've been referred to are, I think, judicial review of a piece of legislation or a measure taken by the state.
That's correct.
Which is said to be non-Article 3 compliant.
Yeah.
And there it's all pretty straightforward conceptually. But that's not the situation we've got here. That's what that's where we're trying to explore.
That is true, but the argument that the appellant is running is that the relevant provision in the 1992 Act is incompatible unless read down. Now, I don't know what the procedure is before the certification officer when a similar argument is raised, and whether or not the Secretary of State...
I don't suppose it's ever been raised before, but we've got to work it out now. Well, it might have.
Forgive me for not knowing the answer then to the question.
Well, I think the answer is you've overrun your time because we have taken you over it. I think this is an area which it's clear we're interested in. We'll hear what the respondent and the Secretary of State have to say about it.
Yes.
And we may hear from Mr. Krasnow in reply.
Yes.
Or indeed she may give some of her time to you if she thinks you'll do a better job.
Very much.
But I'm afraid we've stopped you developing your other points. The truth is they're all in your submission. What you've done already has been very clear and helpful. But I'm afraid you'll have to take your chance on how much we, on the strength of your written advocacy for the rest. I will give you this. If before 12:30 there is some absolutely crucial point you want to make quite sure we've understood, or which you've accidentally omitted, you can make it. But that's it, I'm afraid.
Okay, I will just use that 2 minutes to really highlight the three big points about why the EAT got it wrong, if I may. The first is that they do not make positive findings or positively reject three of the four limbs that are advanced by the Secretary of State. I identified those four reasons. No findings are made in relation to the three, if I would say, concrete ones about reorganisation of the system, etc. That's paragraph 42. That the point they do accept about perceptions is highly tenuous because of the contents of paragraph 125 and the things that my lords have been discussing with my learned friends about what foster carers can already do. And if they can do all of those things, what really would the difference be?
What's the third point?
And the third one is that I think, in fact, you really do have it. It's the position about the NARI reports dealing with a different matter altogether, and certainly not dealing discreetly with the question of collective bargaining or anything of that nature.
Well, thank you, Mr. Burton. I'm sure that was unsatisfactory from your point of view, but you've got a lot of value into it, so we're most grateful. I'll just check with either of my lords. Yes, Mr. Cooper. I'm sorry. Let's see how we go for time. Clearly, as I'm afraid happens so often, the optimistic noises you made on day one have gone out of the window. Having said that, inevitably, appellants tend to take more time because they have to introduce us to the issues. So I very much doubt whether you and Mr. Collins are going to be in serious difficulties. But if you really are, we will make sure you don't lose out in some way yet to be determined.
My Lord, I'm grateful. I very much hope we won't be in difficulties. The practical issue to which Mr. Burton's submissions have led your lordships, and which is clearly a difficult one, really ties into the central theme of my submissions, which is about getting to grips with the practical implications of this case, both in terms of how they affect the whole structure of the 1992 Act and the consequences of how it applies to foster carers, but also importantly for my client, how they affect what the role of the CO might be in this and other cases like it. And the central thrust of my submissions is going to be that an application for listing under Section 2 in general, and this case in particular, is really not an appropriate vehicle. And I use the word appropriate to mean, at the most high level of principle, constitutionally appropriate. It's not an appropriate vehicle through which to try to establish, as the appellant and the IWGB seek to do in effect, a whole series of employment rights for foster carers. And it's not appropriate, first of all, because of where Section 2 sits within the structure of the 1992 Act. Listing under Section 2 is not a standalone right which can be conferred or not. It is central to the application of the definitions under the Act and whether the whole scheme applies or not. And secondly, it's not appropriate for precisely
Can I summarise that by saying it's a gateway?
It's a gateway. But yes, can I come back to that? I'm happy to use the gateway as the term gateway as a shorthand, but that implies that it's a necessary step, and as I'll be showing you, it's not a necessary step. The second reason it's not an appropriate vehicle for what it is sought to be done is precisely the point we've come to at the end of Mr. Burton's submissions, which is that in the end, reading down the legislation in this case, if that's where we end up at the end of the analysis, would involve the certification officer at first instance, or the EAT, or this court on appeal, effectively legislating to change the status of foster carers on what, at its highest, is unsatisfactory and inadequate evidence.
Hang on one second. And I suppose part of that is evidence which, although in the end, because the Secretary of State did come on board, there was some, compared to what's said about its inadequacies, perhaps from both sides' point of view, but in any event, its inadequacies. But they might not have come on board at all, in which case it would have been you who would have had to have produced any evidence.
Yes. And I'll need to return to those at the end of my submissions if that's where the analysis ends up, if all the other hurdles to get there are surmounted, and that's where we end up, we'll need to think very carefully about what the practical consequences would be.
And it's an oddity about this whole litigation, that if W is wrongly decided, this whole complicated series of issues simply doesn't arise, because you would have certified, assuming there weren't any other problems. Sorry, listed rather than certified, but you would have listed, and no Article 11 issue would ever have arisen.
Yes.
But we are where we are.
We are where we are,
yes.
At least for the moment. My Lord, can I just tell you briefly the way...
Can I just make one other observation, which please don't deal with now, but just a point that troubles me, and you're obviously going to deal with because it's been put up front by Lord Hendy in particular. You say it's not a constitutionally appropriate vehicle through which to establish a whole series of rights for foster carers. He says that's not what we're trying to do. We're trying to establish a single right, namely the right to be listed, and that's got nothing, that certainly doesn't have any necessary implication for other rights that come from being a worker, may not even have any necessary implication for other Article 11 rights that come from being a worker. It's just to get us listed. You'll deal with that.
He slightly gives the game away when he accepts, in response to your Lordship's question, that When it then comes to seeking the substantive rights, he and the NUPFC will say, well, look,
That's a little
couldn't
bit
be
unfair.
justified.
I put that point to him because I was just trying to see where it went.
Yes.
He was actually quite careful to say that he accepted it wouldn't be a knockout blow. Of course, he would deploy our reasoning to the extent it was helpful. Why not? But it would. There would still be other arguments to be had.
Yeah, I accept that, and I made the point rhetorically in response to your lordship's question. The substantive point to which your lordship's question is addressed is, I think, a very important one, and is going to be central to what I submit to your lordship.
I'll let you deliver it then.
But before I get there, can I just tell you how the issues are divided between Mr. Collins and myself? He is going to deal with justification, broadly speaking, so the legal tests for justification, including margin of appreciation, manifestly without reasonable foundation, and the implications of the United Nations Charter on Rights of Children. I will be dealing with the following, and this gives you the structure of what I'm going to say to you. So I'm going to start with some core introductory points which are directly addressed to the question your lordship just put to me. Then I'm going to spend a shortish amount of time on some features of the statutory foster care scheme to highlight some aspects of that are important. I'm then going to spend a longer time on the statutory scheme of trade union rights, because that addresses the central point that will be the focus of my core submissions. And then, in turn, I'm going to address whether the trade union rights under Article 11 are engaged, and I use that term, as I've indicated, to mean, are we within the ambit of those rights, but specifically, are we within the ambit of the special trade union rights under Article 11? Secondly, whether there's any interference with Article 11. Thirdly, the questions of other status and analogous situation under Article 14. I will make some brief and focused comments on justification and burden of proof, because they relate to the practical questions that I'm interested in. And I will conclude with reading down. So if I could begin then with my core points. And I start by observing there is a real need to get a grip on what exactly is in issue in this appeal, because the submissions on behalf of the NUPFC and the IWGFB in my submission have a tendency to slide from saying this is all about listing under Section 2 only to invoking and relying upon the consequential substantive rights that follow on from being a trade union. And it really matters precisely what it is we're arguing about, because you need to identify that in order to know whether there's any interference with Article 11 and to what extent. You need to know it then in order to be able to be clear what it is that has to be justified. And you need to know it in particular at the end of the exercise, if you get there, because you need to know precisely the effect of the reading down that is being sought. And the right starting point has to be the appellant's explicit position, for which can I go in the core bundle to page 272, at least I hope it is. Bundles have got out of sync along the way. I'm hoping page 272 of the core bundle is part of the appellant's supplemental skeleton argument with paragraph 29 on it.
It isn't.
Oh dear.
But we got the supplementary solution argument, but para 29 is on page 276.
Well, not quite sure what's happened, but paragraph 29 is where I want to go. And this really sets out in black and white what I understood Ms. Krasnow to hold to in her submissions. In the last 4 lines of paragraph 29, it said, the appellant repeats, this appeal does not seek to secure that its members, the appellant's members, must necessarily be treated as workers for the purposes of consequential substantive rights which may flow from listing. And a similar point is made a few pages on. It's page 12 of the internal numbering at paragraph 37b. In the 3rd line, that the reading down which is sought, it is said, does not modify the meaning of the provision for any other purpose, i.e. it's only where it would result in convention breach. In this case, the only purpose for which the modified meaning of worker would apply is in relation to the right to be listed as a trade union under section 2. So the starting point is that the only thing the appellant seeks is, as it's described there, to read down for the purposes of the right to be listed under section 2. But for reasons that I'll develop in a moment, that is not an apt description of what section 2 is. It is not a right to be listed. Can I develop the points in this way? Listing under section 2 is not an existential requirement for the appellant and does not itself confer either trade union status or any substantive rights.
One second. Yep.
Nor is it a necessary ingredient of being a trade union. An organisation is a trade union because it is one as defined in section 1, not because it's listed as such.
One second.
The primary function of listing under section 2 is that it constitutes evidence that a particular organisation is a trade union as defined, and so by necessary implication that its members are wholly or mainly workers as defined.
So it is a trade union as defined, which includes, is that right?
Which includes
Whether its members are over. Yeah.
And the reason why that's important, of course, is because the whole scheme of rights and responsibilities under the 1992 Act and related legislation is built around those definitions.
When you say those definitions, you mean in section 1?
I mean in section 1 and in section 296. And indeed the definition of employee in 295. So the primary consequence of obtaining listing under section 2 is in effect to get a declaration that those definitions are satisfied for the purposes of all of the substantive rights that depend upon them.
Hang on 1 second. Those definitions are satisfied for the purpose of...
All of the substantive rights that depend upon them. The CO's function, to put it in these terms, is all about the definitions. That's what listing is about. She has no power to adjust the consequences of those definitions applying, nor conversely, if the definitions don't apply, does she have the power under Section 2 to list for some purposes? And if I could quote an important remark that Mr. Hendy made in his submissions to illustrate that. When speaking with understandable horror at the prospect of the IWGB ceasing to be a union if its members were not wholly or mainly workers, he said to you in exactly these terms, he said the IWGB would cease to be a trade union and its members would lose all of their substantive rights, whether the CO delisted or not, he said. And he's right. And that's exactly my point in these core submissions, that listing is not the issue. The definitions and the substantive rights which depend upon listing are the issue. And
I'm sure at some point you're going to take us to the statute provisions.
I am.
You're just building up to that. Okay.
Exactly.
Okay.
As well as taking to the statute to make good all of that, the other point I'm going to make good from the statute when I go through it is that the step of getting listing does not impede the appellant's ability to assert any of those substantive rights, or its members' ability to assert any of those substantive rights in appropriate proceedings at the appropriate time.
Okay, 1 second. Sorry, you say step of getting listed, you mean not taking the step of getting listed? Absence of the step.
The absence of listing will not provide an additional barrier to the members of the NUPFC or the NUPFC asserting the substantive rights that they wish to assert and running their Article 11 arguments in those contexts.
So, for example, a right to collective bargaining against the local authority in court.
Exactly. And I'll develop it, but just to foreshadow that
I understand the point. It's a little bit difficult without a CO listing.
No, it's not. Because what... I'll tell my lord the answer and then I'll develop it by the statute, by reference to the statute when we get there. But what the NUPFC can do is recruit some members. And I don't make these points just to be snide. I make these points because one of my propositions is that what you have before you and what the CO had before him, as he then was an application from a non-operational union with 3 members, not in the remotest position to actually seek compulsory collective bargaining with any local authority, and no rule book. And so if the human rights arguments had been raised, the CO would have been attempting to decide this issue entirely in a vacuum, a factual vacuum, which is what your lordships are being asked to do. So what the NUPFC can do is recruit some members with a particular local authority, go to that local authority and say, look, we have the 10% member threshold that ought to give us a right to seek compulsory collective bargaining. we have good evidence of majority support amongst the bargaining unit that we are seeking recognition in respect of, we would please like you to recognise us voluntarily. All of those are the preliminary steps under Schedule A1 to getting your application off the ground. And in fact, on the evidence before the EAT and the evidence before this court, the NUPFC says the answer would probably be yes. It says there are lots of local authorities that are looking forward to working with us and recognising us. But if the local authority then says no, what the NUPFC can then do is one of two things. It can apply to the Central Arbitration Committee, the CAC, for initiating the statutory collective bargaining process. And in the course of those proceedings, against the concrete factual situation that would then pertain, it can say to the CAC, our Article 11 rights mean that we should have the right to compulsory recognition. And in that regard, the fact that it hasn't been able to get listing and then get a certificate of independence under Section 6 does not present any additional barrier to the arguments that it would have to run anyway about the worker status of its members. And so at that point, all of the arguments that are being addressed to your lordships in the abstract against a non-concrete situation can be heard and determined in a particular situation where everyone understands what the recognition being sought is, what it actually wants to negotiate about, why the local authority has declined to engage with it, and something concrete can be looked at.
Well, I see that would be in some ways good, but the legal issues which we're being asked to determine now would be just the same, wouldn't they?
Not necessarily, because there may be particular circumstances in the local authority which illustrate and provide additional evidence for the difficulties that are. It's the problem of doing it in the abstract. One of the answers to what would happen if the Secretary of State hadn't intervened is, well, that shows why the CO isn't the right place.
Let's just follow what would happen if they did take that route. They would go to the CAC and say, local authority hasn't recognised us despite our fulfilling the criteria. Please, can we now invoke the compulsory recognition procedure? The CAC has various steps to take under that. The CAC would say no. One, it would say you are not a. It would say you're not a trade union within the definition of Section 1 because you don't consist wholly or mainly of workers because your members don't have contracts. And that's all it would say, isn't it?
Probably yes.
So why are we not in exactly the same situation as the issue would then be judicially reviewed?
Yes.
And we would be in exactly the same situation as the EAT, or nearly the same situation. There are procedural differences, obviously, but I'm not sure they're material.
Well, an important difference is that CAC is at least an inter partes hearing. So before the CAC, you have a hearing with the employer and the organisation union seeking
Yes, I see. So the CAC would have a hearing, whereas the CO here didn't.
CO didn't. And
the CO could have. I've forgotten how. The CO didn't have a hearing. Could he have?
I don't know the answer, and I've asked Ms. Russell to.
But they could certainly. CO could, and probably in principle should. This may not be an actual criticism. Could have asked for submissions on both sides.
Well, there isn't another side before the CO. The union simply says, "Will you please recognise me?" The process where it usually works is the CO. Yeah, but as a matter of practice, they do.
Would it follow what you just said? If there was a hearing, it would be an ex parte hearing.
Yes.
Okay, so that's a difference. I think what matters, but otherwise, we would still be in the same position with
Well, we may be, but the answer is we don't know, because we don't know precisely what additional facts of potential relevance would emerge from that process. But at least we would be in a concrete factual situation. But that's not the central point I make about this. Right. My central point is the NUPFC is in no worse position, and potentially the court eventually is in a better position for it to be done that way. And for present purposes, coming back to the function of Section 2, this court is not concerned only with should the right to collective bargaining be conferred upon this union and its members. It is, because of the function of Section 2, necessarily concerned with should each and every one of the consequential rights that follows upon being a trade union with workers as members be conferred upon this union and its members. And it has to perform that exercise in respect of each of every one of those individual rights, which ultimately, you know, if we got to the point of reading down, would be this court engaging in a legislative exercise, balancing all of the competing considerations in respect of each of the rights.
Well, why? Why can't we just say you have the right, effectively we would be saying you are a trade union for the purpose of Section 1, ergo you have the right to be listed as one under Section 2, and insofar as Section 296 would appear not to permit that conclusion, it has no effect. And that is all we would say. Why can't we say that?
Well, the answer is you could, but my rhetorical question back is, what's the point? Because it goes back to what I said about the character of Section 2 at the start. It is wrong for the appellant to describe it as a right to list under Section 2. That's not what Section 2 is. Section 2 performs an essentially procedural or administrative function as part of the overall scheme. It's a declaratory judgment, in effect.
But I understand that point, speaking for myself. I understand that you say you can't split it up. The critical question is whether the NUPFC is or should be declared to be a trade union within the Section 1 definition, and if it is, then everything else follows. And by listing, you, the certification officer, are simply recording a declaration. I don't understand why that question could be more easily decided by the factually more satisfactory route that you suggest of having a real dispute with a real employer who had refused to recognise NUPFC for collective bargaining.
I probably didn't explain it sufficiently well, my lord. The reason why that would be more satisfactorily addressed in that context is because you, the court, the relevant body considering each of those substantive questions, would not be concerned with the overarching question of should the NUPFC be regarded as a trade union and its members as workers for all purposes. They would be asking the narrower, more focused question of do the Article 11 rights mean that those definitions should be read down for the purposes of the right that we are presently considering. And the reason that that's important is because my learned friends start from the position that they don't seek all of the substantive consequences. So what they are seeking by way of this appeal is not for this court to say any more than what my Lord or Justice Underhill put to me, that you are listed as a trade union under Section 2, but not for any of the other purposes. And the reason I infer they make that concession is because they recognise that you can't properly decide all of those other questions in an application under Section 2, because each of the rights potentially raises different considerations. So, to take one example, there is a right to time off for trade union activities. It's a right conferred only on employees. But if you are to ignore the absence of a contract for foster carers, why should a foster carer not say all of the other indicia of employment status are apply in my situation, or at least with a sufficiently close analogy? And so I should have a right to take time off to engage in trade union activities. That raises very different questions from recognition or from strike action.
Slightly calm before the horse. If that were the result of this case, one assumes that the Secretary of State would then look very closely at the bundle of rights which were in issue, applying proper proportionality or justification analysis, say that one goes, that one doesn't, that one goes, that one doesn't. On holidays or weekends, then the position is as follows, and you may get a much more nuanced, delineated approach than we have at the moment. Then judgment wouldn't prevent the Secretary of State from coming back and having a second go on a much more refined and sophisticated basis.
No, it wouldn't, but also why would the Secretary of State need to? If the judgment is given in the terms sought by the appellant, that you are a trade union for the purposes of Section 2 listing only, but for none of the statutory substantive rights that follow, the Secretary of State could sit on his hands and say Section 2 listing doesn't matter because my central point, it's not a right, it's
Well, he could.
has a different function.
He could. And then a whole series of other claims would have to be brought
Yes.
in connection with particular rights under the 1992 Act. And in each case, our judgment will be trotted out and said, well, I know they only declared this, but the underlying reasoning means that you've still got to justify the exclusion, and it will be fought on a right-by-right basis. Now, that might be rather messy, but it's probably inevitable. But why is that a reason why they can't have the declaration limited in its effect as it might be on the meaning of, effectively, as you say, the meaning of Section 1, not the meaning of Section 2?
Well, precisely. But the reason they can't is because it is of no value by itself. So insofar
So this
as
is sort of academic at this point.
it's all academic.
But of course, this isn't public law. It isn't public law. You have a duty to list.
Yes.
That may be empty, maybe, but Parliament has imposed that duty on you, and therefore our correlative right to be listed.
Yes.
And if it turns out to be rather an empty victory because all the big battles are yet to be fought, tough. I mean, it's the battle they've chosen to fight.
But the CO has a duty to list if the definitions are satisfied in order to declare that they're satisfied for the whole purposes of the scheme.
Yeah.
If the CO's action in listing is instead to say, I'm going to give you the title trade union, but none of the consequences that go with that, then effectively you've fundamentally changed what listing is for and about.
It's one step. Section 1 leads to Section 2 independence, which then leads to the definitive nature of the certification, Section 8. I mean, it's a trade, isn't it? I mean, you've got to start somewhere. Why does that? My point is, why does that lack utility under the Act?
My lord, it's not a train, and I'm going to come to the Act and show
Well,
your
perhaps
lordship's
we better do that after lunch. Good. Oh, we'll say 2 o'clock.
All right.